So what led from that type of work to making the shift to personal injury?
Seeing the disparity in how insurance companies treated or attempted to treat people, it really wronged my internal sense of justice and my morals and my ethics. And there were several times that I had cases where I looked at the people that I worked for and I said, I'm not doing that. I'm just not. That doesn't comport with my moral compass. So the shift to personal injury was fighting for the person who's been wronged, fighting for the person who is down, and going up against these behemoths who don't want to take care of people who have been hurt.
This is Courtroom Stories and Tactics by RVA Trial Lawyers, hosted by Sharif Gray and Niall Abuzaki.
All right, we're back, RVA Trial Lawyers, and today we have the privilege of having a good friend, Samantha Cohn from the Brain Injury Law Center, or the Smith Law Center out of Hampton, Virginia. So Sam and I have been friends for a few years, and actually, if I remember correctly, Sam, it was I got a subpoena for stuff in my file a few years ago, and I was like, I've never seen this before. I don't know. And it was a GDC case. And I was like, this seems odd to me. And I remember going on the plaintiff's listserv, which is an incredible listserv. People are super, super generous in terms of helping people out. And I was like, guys, like, what is this? Like, I don't know. And then you came to my rescue and was like, no, Sharif, this is craziness. Like, do A, B, and C. And we hit it off. My guess is we had lunch after that. We've had lunch many times since then. You and I have been in touch. And I, like you, share the love for trial work. And actually, the other week, I think I watched you in trial. And so Sam is one of the few who's not afraid of the courtroom. And when she's there, she does an exceptional job. So super happy to have you. I want to learn a lot about you, where you came from, why you do this work. And then I've got some other questions, especially about service, which I know sounds boring, but it's so important and nobody really knows. And I watched a CLE of yours not long ago, and if anyone knows service in Virginia, it's Samantha Cohn. So happy to have you on RVA Trialers.
Thank you for having me. And it was the VTLA that put us together. Who knows? I answer a lot of questions on there. But yeah, you were kind enough to invite me out to lunch, and we went to lunch. And it's ever since it's been a fast friendship. And I really, really admire everything that you're doing and your own trial work. So it's a pleasure for me to be here. Thank you for having me.
No, it's my privilege. So seriously, it's been a lot of fun. So I'm glad, one, we're friends, and two, that you made time to come on to our podcast. Why people listen to us, I don't know. Probably because of people like you coming on as guests. But for whatever reason, people do listen to us, and so hopefully we're adding some value. But before we get into some of the more substantive stuff, can you talk us through kind of how did you even become a lawyer? Like what did that look like, decision-making process, and then to where we are now?
So, ladies and gentlemen, this is going to be a 9-part series now that he's asked me that question. First of all, I think you give me too much credit and yourself not enough credit. So thank you for that. That's very kind of you. But you most certainly, I admire you. I mean, you're all over the country now doing these awesome trials. It's really impressive. What got me into being a lawyer? I'm a story of that you can persevere and not give up and still fulfill your dreams. I went to 5 undergrad schools. I toured the country. I took a break in between. I thought restaurants were going to be my thing. I decided to go back to school. Spoiler alert, I'm Jewish, so my options in life were lawyer or doctor.
Well, you found a way to now be in a profession that has both, right? I mean,
that's true. It is true. We do a lot of medical work as personal injury attorneys. But when I finally got serious and went back to school, I didn't even get my undergrad degree until I was 28. And at that point, I very much wanted a family. And I thought about actually being a history professor, but I would have needed a PhD. And that wasn't in my timeline for also having a family. It was very important to me. So my dad is a lawyer, my stepdad's a lawyer, my cousins are lawyers. And I grew up with that kind of work around me and went to go visit my dad in DC. Like, he's a big corporate attorney. And so I really enjoyed the work. And also JD degree happens to be one of the most versatile degrees. So even if I didn't become a lawyer, it still gave me a lot of options. So I ended up getting into law school, and I graduated when I was 31. and moved back to Virginia. I graduated from school in Florida. I actually took the bar pregnant. I was 28 weeks pregnant when I took the bar, and my first son was due the day before the bar results came out. So there was no way I was getting a job. And it actually took me a while to find a job since I wasn't from this area. I hadn't practiced yet. I had a very small child, and that was most certainly my priority. And I made that very clear to prospective employers that I was a mom first. And I finally got a job doing insurance subrogation, which is not sexy, not well known. Actually have to explain to a lot of judges how the entire process works.
Yeah, I still don't know what the word subrogation means, but please go ahead.
A good example would be if you're in a car accident and the person who hit you doesn't have insurance, and your insurance company under uninsured motorist coverage pays for you, pays for your medical bills, pays for your car. Your car insurance company then turns around and sues the person who hit you on your behalf.
Got it.
So they are subrogated to your rights to sue that person because they made you whole and compensated you.
Got it.
So it actually gave me a really great foray into personal injury because I was dealing with the car accident cases. I had all of these cases. I just didn't have the pain and suffering aspect because it had already been paid. So it was already liquidated damages. Right. So I got into that work, and you know, you didn't look for clients. I represented Geico mainly, but Virginia Farm Bureau, Northern Neck Insurance, a lot of insurance companies. It was 9 to 5, Monday through Friday. I didn't bring a lot of work home. And so it actually gave me a really great balance of being able to be a mom and still work. And the really huge benefit of it was the fact that it's all pro se defendants well, I shouldn't say all, but for the most part. And because of that, it is no waste of their time or money to set every single thing for trial. So I got a very, very severe crash course in Virginia trial work very quickly. And I think by the time I left subrogation after 6 years, I already had 1,000 trials under my belt because everything just got set.
That's incredible. And then also when you're dealing with pro se, I imagine like you get to the point where you have to know every rule forwards and backwards, right? Because I mean, one, oftentimes courts give pro se litigants a lot of latitude. And then two, like sometimes you just have to put your foot down and say, these are the procedural rules and we need to abide by them. Otherwise it's just going to continue forever. So my guess is that you learned everything you possibly could under the sun when it came to civil procedure and the trial practice.
So, ladies and gentlemen, this is called foreshadowing for our service discussion. That's right. Later.
Smart, right?
That was a good segue.
There we go.
No, it did. It really did. But I took it very seriously. Like I understood that, and first of all, shout out to Chaplin and Gonay, who was the subrogation firm that gave me my start and took a chance on me. And they really gave me a great foot in the door into the legal profession. And I did learn an immense amount from them because yes, when you're dealing with pro se defendants, you need to know every code section, every law, every case. But I took it very seriously to also try to help the defendants as much as I could without having a conflict with my own client. Because I understood it's a single mom with 4 kids who doesn't know if she can pay rent that month. And that's why she forgoes paying car insurance. It's not these people that have millions of dollars that are running around just trying to like tout the system and like damn the man and not have to pay insurance. It's people who don't have the means. So getting saddled with these huge judgments, which a judgment then turns into garnishments. And I don't know how people survive because your bank account is frozen for 3 months. Or it's 6 months at your job and it's this discretionary amount out of your paycheck, which is still a large chunk. And then additionally, you can suspend people's driver's licenses. So now they can't get to work. They can't take their kids to the doctor. So I really tried to work hard with the defendants on trying to find an amicable and agreeable resolution to these cases. But yes, the court gives them a lot of deference, and you really have to make sure you know how to cross your T's and dot your I's when you're making these arguments, because you're not dealing with somebody with a legal background. So they're just wildly flailing around, and you have to be able to give the court the foundation to make its decisions because it's not a regimented normal way that a case is presented to a court. You don't have somebody else abiding by the rules on the other side or who knows what they can and can't do.
Yeah, no, we thankfully don't have that many pro se cases, and for a million reasons, right? But I have one right now. It's a sex assault case, which is interesting. It actually involves kind of a unique code section. It's a U.S. code section, and this man was convicted of child pornography crimes on the criminal side, and there's a code section that when someone is convicted of that, it creates a civil right of action, and it leads to I think it's like $150,000 liquidated damages plus the possibility of punitive damages, and he is not represented. And man, has it been tough.
Yeah.
Right. So, and sometimes it's funny, but a lot of people think, oh, wait, the person's not represented. That should be a slam dunk. The exact opposite. In fact, when someone's not represented, as you've experienced time and again, it makes the process so much more difficult. So, because the issues that shouldn't be there are issues that should not be issues that consume so much time and so many resources. But anyways, that is my brief experience with pro se. So I'm knocking on wood. I don't know if it's the real wood, but that we don't deal with many pro se clients. But that said, I mean, as you mentioned, that education is priceless, right? Like it led to, I imagine, to where you are now. So what led from that type of work to making the shift to personal injury?
So what kind of led me from that type of work to personal injury, like I said, the subrogation cases are essentially personal injury cases absent the pain and suffering.
Right.
It's the same car accident, the same medical bills, the same property damage. Just the pain and suffering has already been paid by the insurance company. And I ran into a really tough place with the pro se defendants. And again, taking it very seriously, I actually had judges tell defendants that they were lucky that I was on the case because I took my title as counselor of law very seriously. And that a lot of other attorneys would just walk in, get their default judgment, and then say it's not my problem and leave. And that doesn't help anybody. That doesn't make anybody's lives better. That's the whole point of the system, right? Is to make the world a better place. And I don't think that does. So seeing the disparity in how insurance companies treated or attempted to treat people, it really wronged my internal sense of justice and my morals and my ethics. And there were several times that I had cases where I looked at the people that I worked for and I said, I'm not doing that. I'm just not. That doesn't comport with my moral compass. And I have to look at myself in the mirror and I don't feel that is right. So the shift to personal injury was fighting for the person who's been wronged, fighting for the person who is down, and going up against these behemoths who don't want to take care of people who have been hurt, who don't want to pay the money that you contract with them to cover you for. And so it was really just trying to do the right thing is really kind of what made me shift into this line of work. And kids, because they're really expensive.
Kids are, yeah. I've come to the realization that my household, I probably own 5% of it. Or the things in my house, 95% of it are my kids and my wife, and I get the. But anyways, I wouldn't have it any other way though. So it's a lot of fun. I have 2 boys. Remind me, you have 3 kids, right?
I have 3 boys.
God bless. Okay. Boys are insane.
Yes,
they
correct.
are absolutely insane. So we're done at 2, but it's wild. But
so I have almost 10. He'll be 10 on the 4th, 7.5, and I was done at 2. And then my husband, I want a girl, and I said, you don't make them. And he kept nagging me and nagging me and nagging me. And I got to the age where it was like, either we're going to do this or we're not. And I realized he wasn't going to stop nagging me until I said, okay. And I said, it's going to be a boy. Just get ready. And so now we have a 2-year-old boy.
That's fun. That's awesome. That's awesome.
And we're very done.
It is funny though how, and I know this is an anecdote, so who knows how widespread it is. But I remember when we were having our second, I was like convinced we're going to have a girl. Right. And I actually was kind of looking forward to having a girl. And whereas my wife was like, no, I want a boy. And so it's just interesting how that works. Right. I think one might assume that guys just want other guys around. and women want baby girls, and that's not always actually true. So
I make a lot of comments to my boys that I literally stop and out loud go, that's why I don't have a girl, because she would be crying right now. And even though I have my nails done and, I do my makeup, I don't even want to do it on myself, let alone somebody else. It's my husband who was like, oh, I want to braid her hair and paint her nails. But no, I was a huge tomboy. I don't think I wore shoes till I was like 8 years old. And so I'm out there catching salamanders in my backyard or frogs with my boys and playing sports with them. So I don't identify. Like I always was more of a tomboy and more masculine. And so I just don't, it's what I identify with as boys.
Well, maybe in some respects, that's kind of why you like the personal injury world, because you can get, I know you get rough, right? Like you're not, people don't push you around when it comes to litigation.
I've definitely had somebody's boss as of late call me. We were getting ready for trial, this attorney and his boss called me after some emails were exchanged, and he asked me to do him a favor and not make him cry in court. I think that I definitely make it clear that I'm not going to be railroaded. I certainly approach everything giving everybody the benefit of the doubt and with kindness. But unfortunately, I think I look younger than I am. And additionally, the reality is this is still very much a boys' game for the most part. And a lot of men, particularly older men, do come in and think if they just get louder at me, I'm just going to acquiesce to their position and agree with them. All of my employers to this point, this is the Smith firm is my third, and hopefully I want it to be my last if they'll keep me. They've all said that they appreciate my tenacity and aggressiveness. And it's not mean, it's not nasty, but I most certainly put my foot down and make it clear that I'm going to speak my mind and I'm opinionated and I'm going to argue my point and I'm not going to roll over to somebody else.
I have had to accept lately, and this was somewhat of a revelation for me, that we should be nice. We should be respectful. We should be professional. But at no point should we ever compromise the duty to our client for the sake of getting along. And I have found lately that, hey, I need another extension. And at some points I just say, sorry, no, we need to move this along, right? Like, and then they'll use, well, how can you not give me this professional courtesy? I hate that word. We have rules in place for a reason. Do your job. Hold me to the same rules. I will be kind, respectful, and I will never make a personal or an ad hominem attack, right? But like, we have a job to do. You have a job to do. Let's go. And then there's the whole, like, in the personal injury world, it's like, well, just be reasonable. It's like, you don't get to decide what reasonable is. And guess what? If there's a disagreement, we have a place to resolve that. It's called a courthouse. Let's go, right? And that's not a threat. I don't make that as a threat. It's the way our system is designed. But there's almost this level of, and I'm sure you can speak to this expectation that you're just supposed to kind of just get along and come to whatever this reasonable number is. That in many respects, I think the insurance company has done an incredible job of kind of setting the frame for that, right? Like, why in the world do we, despite Virginia has 16 different damage elements, if you break out jury instruction 9.0 into every single element, why in the world is every case a discussion about the amount of medical bills, right? Like, not to say that I'm not going to use the medical bills if they're not helpful to my client, but I mean, if someone loses an eye, they're not going to have many medical bills, but are we saying that the value of what they've lost, right? What's been taken from their health, their quality of life, is somehow relevant to the $5,000 bill they got from the doctor who said, sorry, I can't do much for you? It's just not, right? So anyways, I recognize I'm kind of rambling, but lately I've been in fights and I continue to get in fights and it's not fun. I do not like it, but at the same time, I've had to somewhat come to embrace it because I think there's this pressure for us to just be reasonable, whatever that means. And I think there's an expectation that we do so to the detriment of our clients. And I think maybe one of the reasons why I'm so fond of you is because I know that you're there for your client, you believe in what you do, and you're not going to just roll over. And I think that's incredibly important. And I think if you're going to be a trial lawyer, you have to accept that it's going to be lonely sometimes.
So I think there are a lot of people in this world who are lawyers who think they want to be litigators. And then they get to litigation and they go, oh my God, because, and you hear it time and time again. And I was speaking with another attorney yesterday. I had a motion in Portsmouth yesterday, and a good friend of mine, a good family friend, was on the other side. And we were talking about another attorney, and he said it, and it's so true. Litigators are born, not made. It's either in you or it's not. And you can kind of fake it a little bit. But to get up in a courtroom, especially a jury, where you've got a panel of people in front of you that you don't know and you know nothing about them and they know nothing about you, and to make that connection, and then particularly in trial to be able to pivot. Because anybody can walk in there. That's why I love GDC, because it's the Wild West. You have no clue what is going to happen. But in circuit court, it's at least a little bit more rehearsed. You kind of have a roadmap of where it's going. You've done discovery. You know the witness list. You know the exhibit list. Yes, a couple things can still happen, but you still have a pretty regimented idea of what's coming at you. And so people get it scripted, and they have this idea of how the trial is going to go. And then if it deviates, they just fall apart. They can't pivot. They're not flexible. They can't maneuver around it. Like, what if you have this huge piece of evidence that's got to come in, and for whatever reason, the judge keeps it out? And now you have to figure out and scramble how to make it around that and still put your case together. Regarding what's reasonable, I tell my clients, I love litigation. I do. I love being in a courtroom. I don't want to have to take them to court because that's a lot of time and money. But if an insurance company is not going to treat them right, I'm going to Thelma and Louise the case off of a cliff, because litigation's a game of chicken. That's what it is. It's the defense and the plaintiff, and they're driving at each other, and it's who turns first. I'm going off the cliff. I'm aging myself with a Thelma and Louise reference. So
Yeah, I have no clue what that means.
oh my, I'm going to jump off the roof of the building after this. Please watch Thelma and Louise. Everybody who hears this and doesn't know that reference. So when it comes to being reasonable, I find that there are very vast discrepancies between what you and I think is reasonable for our clients and what an insurance company and their defense attorney finds to be reasonable. It's absurd. It's patently absurd most of the time. And then you're pulling teeth trying to get them to come up to where you are. And you're 100% right. It's not based on bills. And actually, the trial that I just had a couple weeks ago in Henrico that you mentioned, I didn't introduce one single cent in damages. I put the ledger in of what his treatment was and what his diagnoses were. And that was a battle too, because I was moving it in as a bill, but it didn't have money amounts on it. So the defense attorney was like, well, it's not a bill then. And so we had to have that argument before the jury came out. But I didn't put any money on it. I didn't put any bills forward because I thought they were going to be limiting, because it was a VA. It was VA treatment.
Right.
And so I thought it was going to be very limiting to him. And so his case was all about his experience and what he had gone through and what happened from his perspective. But this be reasonable is more like roll over and come over to my side and agree with me so I don't have to work too hard. That's what it translates to me. And I'm all about courtesy. Look, my kids get sick. There's a baseball game, school's closed, something happens, and I need an extension on a deadline. But I'm only going to ask for one. It's not going to be a repeated, like every time something's due, or like multiple times for one thing, like an expert designation. So I give everybody one because things happen. But after that, like you said, I need you. We have rules. And if I was blowing by these deadlines, you'd be mad. You'd stop giving me extensions at a certain point. And we have to prep the case the way that we have to for a certain reason, particularly like expert designation deadlines. They're 90 days for us and 60 days for defense. If we want to do depositions, if we have to do rebuttal experts, we're not going to have enough time. And I don't want to have to continue something. My client doesn't want to have to continue something. Same thing with discovery responses. I give people leeway. I know it's hard to get it together, but then that sets us up to do further discovery and do the depositions, and we need to get all that information. Because I don't know about you, but we like to set trial dates. You know, once the answer is received, we move to start setting trial dates. I want the defense to see that freight train coming at them and to know that we're serious and they're not going to be able to play around and drag their feet in trying to get this resolved.
You have to have a trial date. Let me tell you, one of my most recent fights is actually on this very issue. Corporate defendant is thinking they don't even belong in the case, asked me to dismiss them. Like, no, we sued you for a reason. Like, we're not just dismissing you, right? And then they file a motion to dismiss, all this stuff, right? And we're getting things moving. Like, I'm issuing discovery, I'm setting depositions, and then I go, hey, let's get a trial date. They are like, okay, we don't think a trial date's necessary. And I'm like, sorry, there's no rule, respectfully. And I said, respectfully, there is no rule that says that you have to be ready for us to set a trial date. It just doesn't exist. If there is one, share it with me, but there's no rule. Respectfully, we can do this one of two ways. We can get on the phone with Chambers and we can set a trial date, or we can go do a docket call. And so they go, okay, we can get on the phone. The next day, what do? They file a motion to quash setting a trial. And then what do? 3 days later, they ask for an extension for discovery that was due that next day. And after having already gotten 5 or 6 extensions from me for an answer, so we could go mediate, when they offered my sexual assault victim, that's guy's already pled guilty, they moved twice at the mediation, $500 the first time and $500 the second time. And so then I get the be reasonable professional courtesy, right? So like,
so rude.
Anyways, not that this is a therapy hour, but now it feels somewhat cathartic being able to talk to you about this. But in some respects, I mean, being a trial lawyer, a plaintiff's trial, you are putting yourself out there, right? Like, I mean, there's the stigma, you're the billboard, the ambulance chaser. I'm a big proponent of our main job in a courtroom is at the very beginning, while you can't do it explicitly, but it's to change the perception of what the jury likely perceives of you, that we're here in this courtroom because the plaintiff's greedy, the plaintiff's attorney's greedy, and the settlement wasn't good enough. And so what our number one job is to find a way to change that. So the jury is like, no, we're here because of the defense. They're the ones being unreasonable. They're the ones saying that, making these crazy arguments. And I think if we can do that in a trial, we've positioned our client in such a better position in order to actually get a legitimate victory.
I have a wonderful client, and he came to me very begrudgingly. He's actually a doctor, and he once got sued for medical malpractice. Totally bogus claim, but it left such a bad taste in his mouth regarding personal injury attorneys. Because he was like, oh my, I didn't do anything. And then this attorney comes and they're trying to sue me for all this money. And he gets in this terrible accident. And sadly for him, he had USAA insurance, which I'm sure you know is one of the worst when it comes to paying.
You know what? I have USAA. I've enjoyed banking with them. I've had their insurance forever, right? But like,
did you need it though?
You know what? If someone comes to me and says, hey, Sharif, like, who should I get as an insurance carrier? I don't know who to say. I mean, they're all tough.
They are all tough, but I think some of them are better than others. I'm gearing up to sue a couple of insurance companies for not paying MedPay benefits.
Yeah, that's not good.
And USAA is one of them. So, but he was trying to do it himself with USAA, ended up having a cervical fusion. The beauty of it was he could also be his own expert because he's a medical doctor. But he came to me literally kicking and screaming. And he was referred to us by his business attorney because he owns some businesses. And he said, I don't want to do it, but who would you recommend? Because they're just being too obstinate and I can't get anywhere. And so he was referred to us. And he came in and he was so standoffish and made it so clear from the get-go. And this is the plaintiff, not even the defense, not even the jury, the plaintiff coming in and saying, I don't want to be here and I don't like you people. And we are the best of friends now. He's such a cool guy. His daughter actually interned for us over the summer. I hate to say it, he was in another car accident. And I told him if he wanted to hang out with me more, he could just invite me to lunch, not get in another accident. But he left me a glowing, beautiful, heartfelt review about how I had changed his mind regarding how attorneys, particularly personal injury attorneys, function and what they do, and that we're not ambulance chasers. And I know for me, what's really important is having open and honest communication with my client, being available to my client. I find a lot of people say, I call my attorney and they never call me back. I can never get answers. I never get to speak with anybody. But also, I'm not shy to admit it. I cry a lot with my clients. Like when they tell me about what they're going through, and like you said about this being kind of cathartic, you know, we tell our clients, you can't talk to the insurance company. You can't talk to a lot of people about this. They don't have a lot of outlets. And so we kind of do become that counselor at law for them because they don't get to speak to a lot of people about what's going on and their frustration and their ire. And I take it very seriously to give them that sympathy and that empathy. Sadly, I've gotten involved in some fetal demise cases and I just cry. I just cry with the moms and I just hug them and I just cry. And so that's what gives me the drive, like going back to being reasonable, that the insurance companies and the defense attorneys don't see this side. They see it as a business transaction. They see it as a case and nothing more. I don't see it that way. I see this as somebody's life and I am responsible to help them somehow trudge through and guide them through what is the most difficult, at least one of the most difficult, if not the most difficult thing that they're ever going to have to go through in their life. And so for me, these aren't cases, whereas I think for the insurance companies and the defense attorneys, they're cases. For me, every single case is an individual and it's their story.
Let me add on to that. So one, I agree with you completely. Something that I've noticed is that while our cases are all about money, at the same time, they have nothing to do with money. And as weird as that sounds, right? And I recognize the listener's probably like, huh, he's full of it. And to some extent, I probably am, right? There's plenty of things that I'm full of it on. But my clients, with rare exception, talk about accountability. They talk about they don't want this to happen to the next person. They talk about how their life is not the same, how they can't play with their kids the way they want, how they're in their 60s and they were looking forward to doing A, B, and C, and now they're stuck at home, right? Rarely does it come up, hey, what do you think my case is worth? Hey, I mean, it does happen, right? And ultimately, so what is money? Money is symbolic in the sense that money is what is the only tool we have to recognize the value of what's been taken from somebody, and that's their health and their quality of life. And for me, and it sounds like for you as well, that's kind of the drive. That's the purpose. I've had so many cases where had the other side come out at the beginning and said, guys, we're sorry, let's do what we can to make it right, probably would have never gotten the phone call. I mean, I had a wrongful arrest case that we made the front page of the Richmond Times, and it settled for a significant amount of money confidentially. And I'm confident that if that county's police department came to my client who was innocent, and they knew was innocent, and they had clearly violated his constitutional rights, it was on video, right? Had they come to him, shook his hand, said, we were wrong, we're sorry, what can we do to make this right? I would have never been involved. But they fought and they doubled down. And here we are. And I mean, there's so many of my cases, and I guess I should be grateful, right? Or we should be grateful, because that's how we keep our jobs. It's job security. But time and time again, instead of just doing what we believe is the right thing, and what I think most people would think is the right thing, accepting some responsibility and allowing everyone to move on, they fight. And so anyways, but I like to fight just like you. So it gives me purpose, right?
Well, going off what you said, I have a fetal demise case that I partner with Les Bowers at Michi Hamlet with, because I don't know MedMount and I most certainly don't know that aspect. And so knowing that, another part of being a lawyer is being humble enough to know when you're out of your element and it's beyond your depth. And I don't know anything about this. I don't know anything about this other than a family has been ripped apart and there's not a baby here that should be. Talking about the money aspect, no amount of money in this world would make it okay, would make that family okay, would make that mother feel okay about losing her first child at full term, like in labor, and the labor goes awry. No amount of money in this world would compensate for that. And so when I talk to my clients, I go, look, like you said, it's about accountability, responsibility, saying you're sorry. And when I'm talking to them about settlement or verdict and what we're asking for, what we're filing for, we go over and have the discussion that nothing makes them whole. It's not, you can't put it back together. It's like the adage where you throw a plate at the wall and you say you're sorry. It doesn't put the plate back together. Nothing is going to make up for, particularly, I think in a lot of our cases where there are catastrophic injuries, nothing is going to make them whole again. And like you said, money is the only thing that we can somewhat give to them to try to compensate them for what they've gone through. So when I talk to them about it, I say, look, you have to find a number or think of a number that makes you content. That's the goal, something you can live with. Because it can't give you your child back. The jury trial that I just had, it can't put the muscle back in his hand and make his hand functional again. So the only thing that we can do, the only thing that we have in the system, like you said, is to give them the money. But I agree with you wholeheartedly. That is very rarely the driving force in the majority of these cases.
And maybe I'm wrong, but I have this feeling that like the stigma is that's all we care about. It's money, money, money. And I mean, to some credit, we've earned that reputation. Like the plaintiff's bar as a whole. I mean, I share this kind of example all the time. I tell people who aren't terribly familiar with the work that we do, I say, listen, there's a massive spectrum. There are people who could care less about the client and will never file a lawsuit, and they will take whatever the insurance company gives them, and that's how they run their business, right? And then there are lawyers on the complete other end of the spectrum that are doing very high-level, sophisticated work and care deeply about the work that they're doing. And then there's all of us in the middle, right? And so
I wouldn't say you're in the middle. I think you're towards that other side.
Well, thank you. I hope so. There are a lot of good lawyers in Virginia, and I think we've got a great group of people who truly believe in this work. And I think ultimately that's kind of what separates those from one end of the spectrum to the other is, do you care? Do you believe in this work? Do you feel that purpose, that calling, right? And because in many respects, kind of like why I loved criminal defense when I did in the Army, one, I got to represent some pretty awesome people, right? They were soldiers. I was at Fort Bragg, and so by happenstance, Fort Bragg has Delta Force, the 82nd, a bunch of Green Berets. And so I got to represent some rock stars. It was awesome.
Cool. I said Thelma and Louise and I lost you. Now you've completely lost me.
That's right.
So we're even.
Well, for those who have any military background, they know what I'm saying. At least I hope. But it was very cool. But why are criminal defense attorneys often motivated to do their work? Yes, do they care about the client? Of course. But larger than that, the greater purpose is they are representing the Constitution, right? They are standing up and saying these rights matter, and they matter to everyone, to include the weakest link in our society. Because if they don't matter to that person, then they're going to come after us. And I think the way we can look at our work on personal injury is like and I recognize this is going to sound corny, so close your ears if you don't want to hear it, but we represent the worth or the value of human life, right? Like we get to stand up there and say, yeah, the defense is saying the medical bills are 20 grand and that therefore the case should settle for 40,000, whatever it is, right? And we can get up and say, we don't need you, judge or jury, to tell us what the medical bills are. We've got calculators for that. But what we do need you to do is to recognize the value of what's really important. The inability to choose how you navigate your day at no fault of your own because someone was on their phone and they slammed into the back of you, right? Like the inability to take that trip or to spend time with a loved one, or in worst case, in the wrongful death scenario, the inability to have that relationship with somebody who's been taken from you because this corporation put profit over the safety of the community and incentivized their driver to make 1 million stops, to push past the time that he should have been driving, to drive fatigued, right? And so that, I think, to me is again, as corny as it sounds, is my big motivation. Like we get to stand up and say that, you know what, the ability to choose how you go about your life is important, right? And when that's taken away from you, when you're dealing with these health issues at no fault of your own, when you're not able to do certain things, that has real value. It's hard to put a number on that, but that stuff's important, and it's certainly more important than whatever this administrative professional decided to charge you in medical bills.
I tell every single client that it is my privilege and my honor to take care of them, because we give a voice to somebody who is otherwise going to be dismissed, whose experience is diminished. And to go back to what you said, because of profitability, because these insurance companies are beholden to their shareholders, and it's all about how much money they keep in-house. It's not about doing the right thing for them. They don't care who you are, how long you've paid for coverage with them, how long you have been a member with them. At the end of the day, it is about keeping as much money in their pocket as they can. And so they essentially throw people away, and it's heartbreaking to watch. And again, you're taking people in some of the worst, if not the worst time of their lives. And all they're hearing from this insurance company that they've paid for 20 years to be part of and thought was going to take care of them, that they don't care, they're not important, that they don't see them. And so, like you said, we get to stand up.
Yeah, and tell
we
their
say,
story.
no, this matters. They matter. What happened to them matters. It's important, and you're going to hear it. And if you're not going to pay attention to it, we're going to get a jury of their peers, and I'm going to make them really angry that this is the route that you've chosen to take. And they're going to do what they think is right, which most of the time is completely in contradiction with what the insurance company's position has been. Because it's not about money and profit. It's not about profit to the jurors. It's about trying to make it right.
Absolutely. And it is amazing when you truly like embrace this mindset, like things start to make sense. Why is the defense saying they're not ready to set a trial date? You know, like, why are they asking for this motion to continue? Wait, why are they so late on discovery? Why didn't they respond to my third email on this issue? It's like, it makes sense now, right? Because at the end of the day, the only thing that can hold one of these insurance companies accountable and actually allow for the possibility of fair and full compensation, right, is a jury trial. And so that's why, I think if you're going to be a trial lawyer, if you're going to do this type of work, like, you've got to be fearless. Obviously you can't be reckless, but when it's time to suit up and to go to court, you got to be ready and you got to be willing to do it. Because if you're not, everyone knows, right? This whole idea of that the insurance companies or defense attorneys are not tracking who is willing to try.
Know.
They know.
They know.
And it's a real and I'm even a big believer, and again, this is me on my soapbox, but there is no such thing as a loss. You walk into trial, yes, there is a loss, but you went the distance, and that defense attorney, that insurance company, they'll remember the next time. Right? The next time you have a trial, they'll remember all the motions practice you went through. They'll remember the prep. They'll remember how you took them all the way to verdict. And they'll remember that, so your next client hopefully will benefit from that. Again, that's not me saying just take every single case to trial.
Right.
There are cases that need to be resolved, and they should be resolved. But the cases where the insurance company doesn't give you a reasonable offer or an offer that makes sense for your client, we don't cower to that. You look at that as an opportunity to go out and actually get a jury to come up with a just decision. And that's, to me, the most professionally rewarding thing I think I could ever do. And Sam, it's clear to me, having watched you and been friends with you the last few years, that you feel the same.
I have a very good friend of mine who was a defense attorney and now does PI, although just for funsies, if he had a warrant and debt come in the door with my name on it, he would take it pro bono just to poke at me in court. But he once told me, he said, you know why I'm scared of you? Because you're fearless. He goes, you don't care what warts the case has. You don't care what shortcomings it has. If it's got to go to court, if the right thing is to take it to court, you're going to pick up your shield and you're going to pick up your sword and you're going to run and you're just going to do it. And yes, every case, I just put a recent post on social media. I don't like the quote unquote easy cases. I don't like the clear liability. I don't like the no pre-existing conditions. I want the underdog who has the pre-existing. I want the light dispute. I want the fight. I want to help that person who maybe other firms have turned down because they don't think that they have a chance of being successful. And I find real gratitude and real fulfillment in taking the circumstances of that person's life and reshaping them and presenting them in a way to the jury to really give them the human aspect of what's gone on. And it isn't about taking every trial to court or every case to court, because sometimes it doesn't make sense financially. If you're, maybe a couple grand off between what your demand is and what the offer is from the insurance company, but then, man, I got to pay 10 grand to this expert. It doesn't make sense in that case. And you counsel your client. If your client chooses otherwise, your client chooses otherwise. But yes, you most certainly can't fear going to court. And defense attorneys do know. They know there are certain firms where they just prefer to settle. They know that there are certain PI attorneys that you get them to settlement conference or arbitration or mediation, and maybe not arbitration because that's binding, but mediation or settlement conference, and they're going to settle because they don't want to go to court because it makes them uncomfortable. Another big aspect that you talked about is the motions practice. I find there are a lot of PI firms that don't do a ton of motions practice. They'll do the discovery, but they're not doing the motions in limine. They're not doing all of the kind of end game, maybe a motion for summary judgment as to liability and knock that portion out and give you more leverage to negotiate a settlement. Because at the end of the day, it's a verb for me, a jury is going to jury. And you don't know what's going to happen. All you can do is do your best. And like you said, even if you take a loss, as long as you set yourself up the best way you could, and as long as you did everything you could and took all the steps and filed all the motions and got all the evidence, at the end of the day, as judges like to say, you're in front of 7 people who weren't smart enough to get out of jury trial.
That's right.
And so they're going to do what they want to do. And I don't know if you've ever done mock juries before when you're prepping for cases.
Sure, yeah, we do focus groups.
Right. So you do mock jury focus groups and you watch them, which is weird because it's like staring into a fishbowl. It's like behind the curtain in The Wizard of Oz. Do you get that reference? I
do get that reference.
Thank God. There's one. But it's watching them and they always latch on to the weirdest, most random facts. And then they make these huge inferential leaps that don't make any sense. And it's so bizarre to watch the mechanics of it, the machinations of these people and how they get to the end result. So all you can do is try your best. And I agree with you. It's not a loss. It's more experience. It's more knowledge. It's maybe learning that defense attorney, because there are tons of people I know that are defense attorneys that are one person when you're having conversations with them. And then you go to court and they are completely different. They may be the nicest person before court, but you get in that courtroom and they're super aggressive and they're really loud and they're really pushy. And you weren't ready for that. That's not the mindset you had going into it. So I don't think there's ever a loss as long as you're doing the right thing and trying your best.
And you're learning from it, right? And you're learning from it. How do you get people to that? I mean, fearless I think, is too high of a standard. We're all fearful. Right? I still to this day, have nerves before court. And I hope I always do because it means you care, right?
Every single time I walk into a courtroom, that first 5 minutes, I am freaked out every single time, whether it's a motion, whether it's a return, whether it's a trial, every single time.
I tell people it's you just need to get to the first objection, right? And then you're kind of warmed up. For the younger lawyer who is you know what, I want to do this type of work. I want to be fearless, right? And I think fearless it's just a word. No one, as I mentioned, no one's truly fearless. What do you do? How do you get the reps? What do you tell someone to do to try and improve, to become a trial lawyer? So when it's time to to give your client the advice they need about whether to take maybe the too low of a settlement or to push it to trial, they're not in their mind thinking, I'm just a little scared to go to trial, so I might lean a little heavier on settlement.
My advice would be to surround yourself with people who are smarter than you, people who have attributes that you admire, people that you can seek mentorship from. I know with me, I'm really big on having, I've had several interns. I've had several mentees that are my seconds in jury trials. And even now, like I'm seconding for David Holt and Stephen Smith and Stuart Gill, because at the Smith Law Center and the Brain Injury Law Center, they've been in the game a lot longer than I have. And while I may be seasoned, I don't know traumatic brain injuries in and out like they do. And so for me to learn that, I go hang out with them. I should say annoy for the most part. I think that's especially for David, it's a better adjective. But I think it's, like you said, it's getting the reps. It's doing the work. It's going to court, whether it's filing the motion and having the motions argument, whether it's seconding on somebody else's trial, if it's coming and observing somebody else's trial. The more you're in court, the less affected by it you are. I agree with you. The day that I stop being nervous means that my head has gotten too big and I need to get out of my own way because my ego is so big I can't, my head's not going to fit through a doorway. I think every time you should be nervous because you don't know what's coming. You don't know what's going to happen. And if you really genuinely care about your client and you're worried about the right outcome, you're going to be nervous. So I think a big part of it is just getting in there and doing it and taking on going to general district court. I think a lot of people really look down upon and frown upon general district court because, now the cap is 50. It was 25. So it was really small potatoes and it wasn't anything fancy and you're not really getting complex cases and there's not necessarily a lot of argument. But general district court is where you really have to hone your skills because you don't know what's coming at you, because you don't have discovery, you don't have witness lists, you don't have exhibit lists. You have no idea. I had an attorney one time.
Fictional subpoenas, remember that?
Well, I had I had a defense attorney one time who argued that I couldn't put on a witness because he had not received a subpoena for that witness. And I looked at the judge. I go, any Joe Schmo can walk through that door right now and get on the stand if they have something relevant. I don't need to issue subpoenas to people. And the judge was like, yeah, we're in GDC. Like, what do you think is happening right now? So you don't know what witness is coming. You don't know what evidence is being presented beforehand. Like right now, I have a Stephen Smith case, it's a personal case, and it's against a huge corporation, and they're used to federal work, and we're in GDC. They have no idea what they're doing. They're issuing me absurd subpoenas that they're actually requests for production couched as subpoenas. They filed a motion for summary judgment that with the evidentiary, and I put that very loosely in bunny ears because they did not authenticate anything. They did not have any affidavits or anything. But with the evidence that they used to support their motion, it was 85 pages long. We're in general district court. Yeah. Like I didn't even bother to write a response brief because we're in GDC. And I walked in there and the judge was like, what's your response? And I was like, this is the most improper motion in ostensibly every single way that you don't even have material facts to be able to argue that there are none in dispute. Because we are a notice pleading state. All you know is the date that happened and he was injured and how much I'm claiming. You don't know how it happened, where it happened, what went on. And so I think GDC is a lot of attorneys just need to get in there and get their hands dirty. You don't really have a lot of experts. You're not going to really have a lot of costs. You've got service costs, maybe a subpoena here or there, subpoena duces tecum for something. But other than that, just get in there and do it. And that's gonna teach you the code sections. That's gonna teach you the case law because you don't know what argument is coming. And so you better have all of those weapons, all of those, quivers all those arrows in your quiver. I'll get there eventually. You'll have all those arrows in your quiver for when you go and be able to spout out the case and be able to shoot off the code section because you're gonna have to be prepared to say it every single time. And then, like you said, don't be scared to do the motion. Go argue the motion in limine. I think not nearly enough attorneys use motions in limine to narrow down the evidence and to keep out what shouldn't come in. And it really makes it a cleaner trial. It's more advantageous to your client because as much as a judge can be like, oh, sustained, The jury heard it.
Yeah, the bell's been rung.
You can't put the toothpaste back in the tube.
Right.
So to do these motions in limine and have clear bumpers, like a big one that we do a lot is for experts, that experts can't state other experts' opinions in the literature that they read or the studies that they base their opinion on. And a lot of experts are like, oh, it was a low speed minor accident with little
They don't have
property.
any personal knowledge. They don't have, and that's hearsay that they're getting from a police report or for whatever they're getting it from. And they're just regurgitating. And that's completely improper, right?
But even if it's not the police report, even if the defense attorney has presented them with pictures.
Sure.
Oh, you're an accident reconstructionist. You're an auto body mechanic now. Cool that you do that on top of being a neuropsych. You must be super busy. So things like that very much, if that comes out of the mouth of a neuropsych expert at trial, the jury's going to take that as gospel. They're going to say, oh, it must have been a low-speed accident when they have no business saying that. And it's in most of their reports. It's in I saw the pictures and based on my interpretation of this low-speed, no-damage accident. So I think to get in there and make those arguments and to get into court as much as you can, there's no I shouldn't say that. There are stupid reasons people go to court. I get motions for them all the time, like the motion for summary judgment. But as long as you have a good faith basis to argue something, to file something and argue something, it's just getting into court. And the more you exercise that muscle, the more comfortable you will become being there and being present there.
I always like to ask this question, and because it makes people think, I think. But you may have already actually answered it. If you could go back in time to when you were first becoming a lawyer, what would you tell yourself? Knowing what you know now, of course.
Knowing what I know now, you know what? It's what I tell all of my interns, and it's what I tell all of my mentees. It is to be true to yourself, to follow your own moral compass, because at the end of the day, your license and your reputation are your own. And it doesn't matter who your boss was. At some point, you're probably going to switch firms. And if somebody thinks you were a jerk at one firm, they're not all of a sudden going to be like, oh, but he switched firms, so he's not a jerk anymore. So it's very important to do what you feel is right. And I also tell them, don't do it for the money. If your heart's not in it, you're in the wrong profession. This is not what you should be doing. If you love it and then you become good at it because you care and because you love it, the money will come. And so for me, it was just, I don't know why I have this very strong sense of internal justice and kind of doing the right thing and helping people that are downtrodden. But it's really just being true to yourself and finding your passion and following it.
Sam, this has been a lot of fun. So thank you for joining us.
You're welcome. Thanks for having me.
You love how we talked about service?
I was going to say, sir, okay, here's my 30 seconds on service. It's really super important. Don't screw it up. There are lots of ways to do it based on if it's a person, a business, a trust. I have a CLE with materials. Feel free to reach out to me and I can share them with you.
This has been a lot of fun.
Thank you so much for having me. It's been a pleasure. I'm glad we finally made it happen because, again, I really admire you and I'm very impressed and I can't wait to see what you continue to do with your career.
Thank you.
Thanks for listening to Courtroom Stories and Tactics by RVA Trial Lawyers. Hosted by Sharif Gray and Niall Abuzaki. Please subscribe and leave us a review on Apple Podcasts, Spotify, YouTube, or any major podcast platform. Together, we're building a tribe of trial lawyers to remind the world what human life is truly worth, one verdict at a time.